for the benefit of our listeners, especially the uninitiated, explain the difference between the UAM and the Freedom Party.
Well, the United African Movement was actually started in 1988. It happened during the struggle for justice for Tawana Brawley, and it was established actually on August 17th, 1988, in honor of the Honorable Marcus Garvey. And it has continued as such until this present time. It does a lot of activities concerning the education and liberation of our people. But in addition to that, in 1994, we started the Freedom Party. And the purpose of the Freedom Party was to continue the legacy of Fannie Lou Hamer and the Mississippi Freedom Democratic Party, and to give black people a political voice, one in which is not shared by participating in the Democratic Party. And so, and obviously, Sister Hamer made that very clear in her confrontation with President Lyndon Baines Johnson in Atlantic City in 1964. And so that has continued until this present time, and there have been times when we have sought ballot access, and it should be pointed out that New York is a very racist state, and it basically only sees black people as participating in plantation politics. In that we are basically like we would be on a plantation where only our labor is needed, but not our advice, not our ability to bargain, not our ability to promote our own self-interest, or any of those things. And that's basically the same condition that we had on the plantation. And and so the Freedom Party has tried to break away from that, but of course, as you can understand, it's not in the best interest of white supremacists for black people to have their own political voice, to be able to leverage their numbers, and to be able to bargain for things that are in their best interest.
Right. You, of course, have been at the forefront of some highly publicized cases, like what you already mentioned, Tawana Brawley. We also have the Central Park 7 among them. And, I noticed that one of your Central Park 7 foremost nemesis is now running for president. Okay. And he is not offering any apology at all towards any of them, even though it's been proven that they are not the rapists of that jogger.
Well, there's no question about it. And I think what is dangerous about Donald Trump and his candidacy is that people do not know just how involved he was in the annihilation of the Central Park 7 if he had his own way. And so, among other things, he called for the execution of these young boys, despite the fact that the Supreme Court itself had ruled that the execution of juveniles is unconstitutional. But he took out full-page ads in the New York Times in order to bring that about. And ultimately, he had an impact in convicting 6 innocent black and Latino boys. And then afterwards, he also went after the attorneys, particularly the black attorneys. And people don't mention this, but all 4 of the black attorneys who had temerity to speak out on behalf of these 7 boys, were actually disciplined themselves. 3 of those lawyers were disbarred, and the other one was suspended for a specific period of time. And so it shows you how vicious this man can be, and he has the same mentality as whites would have had in the Scottsboro boys case in Alabama, had 4 black lawyers showed up at that particular time to defend them.
Well, I'll tell you one thing. The next step for him to do, after doing all the, calling for their execution, the next step after that would be to call for another Tulsa. And he just bombed New York City altogether just out of, angst towards that Central Park 7.
Well, I think that's in his cards if he gets an opportunity to be president of the United States. Because from a business point of view, and I think black people got to look at Donald Trump from a business point of view. Donald Trump is the graduate of a military academy. And in addition to being a graduate of a military academy, he is also a graduate of the Wharton School of Finance. And the question then becomes, are we still useful to the United States? Some black people like to flatter themselves and believe that we are. I'm one of those who don't believe that. I'm one of those who realize that it's way back as far as Dred Scott, and certainly beyond that to the formation of the U.S. Constitution. What we don't realize is that the political system in this country is based on a balance of power. And so it doesn't matter whether we are part of that balance, as the so-called founding father was concerned about when they made a 3/5 of a person back in 1987, or whether they bring in refugees or they bring in immigrants or they bring in any other group who's not a part of the United States landscape right now, and put them as replacements for us in the balance of power. And I'm one of those who suggest that anybody who understands anything about a business would have to readily conclude that we are the odd persons out. This is a game of musical chairs, and when the music stops, if we are not correcting ourselves right now, we're going to be standing, which means we're going to be eliminated.
Very profound. The thing about it also, if I can add, I remember there's somebody on Twitter addressed Mr. Trump regarding the Central Park 6, and they said, well, the fact that the real guy confessed, that proves he was wrong. And his remark was, so what were the rest of the guys doing, playing checkers? So, this is typical Donald Trump now. He ain't backing down for nothing.
Right, well, he's definitely not getting ready to back down. He has his own agenda, and he's planning to push it down everybody's throat.
Oh, yeah. And once it gets to that point, as you said before, it's no longer really about the Central Park 7 or 6. It's about us.
That's correct.
Our annihilation. That's the thing.
And that's exactly the way he looks at it, because if you go to business school, you realize that when a product is obsolete or a market is obsolete, you have to end that market, the existence of that market. And that's the only decision that Donald Trump is going to make, and it's not going to be a difficult decision for him.
Very true, very true. You're listening to 3600 Seconds. Our guest today, Mr. Alton H. Maddox, Jr. If you have a question or comment for Mr. Maddox, you can dial 646-200-4444. No, I'm sorry. No, don't call that number. 347-426-3040. Call in 347-426-3040. We have a number of callers here right now. And if you have a question or comment, Mr. Lewis, we'll start off with you. Or any one of you. Mr. Maddox, suppose, what I want to give, because I know in your columns you talk a lot about military science. Could you explain that?
Well, the thing that people have to do is to reduce white people to their lowest common denominators. We learned that when we take arithmetic, and arithmetic still is the basis for numbers, and it still applies. And you can take that beyond arithmetic and into other aspects of life, and realize that the white man is bilingual. He only speaks 2 languages. It's very important to understand that. And those languages are legalese and military science. That means that if you are represented by somebody who does not understand legalese and does not understand military science, you're not enjoying any effective representation, because you can't talk to somebody who does not understand pig Latin or some other nonsense that you might be engaged in.
That's true. That's very true. Speaking of which, I noticed you didn't consider the firing of Sheriff Deputy Ben Shields to be a victory. I know I read one of your columns recently, and I know probably quite a few blacks probably would, but why do you feel that way?
Well, that really goes back to law school with me, and then coming out of law school. And in the first year of law school, there are certain basic courses that law students have to take. And among those basic courses are criminal law, and it is tort law. And so, that's the basis for you're beginning to appreciate the legal system and the critical areas in the legal system. Now, what is interesting is that when I finished law school and then started practicing law, I first of all recognized that nobody who is black or white or whatever the case might be and get a law degree and then pass a bar examination is qualified to represent black people, because the curriculum in any law school is not designed to represent descendants of enslaved Africans or slaves themselves. When you start looking at law schools like Harvard and William and Mary down in Virginia, some of the earliest law schools in the nation, what is clear from those law schools that we were still in slavery when they were formed. So there was no reason for those law schools to develop curriculum to make sure that we were beneficiaries of the effective and zealous and competent existence of counsel. And so as a result of that, I, for one, began to re-examine my own self in terms of what I was competent to do. And so I spent time when I first started practicing law actually writing a book, How to Effectively Represent Black Defenders. And out of that book, I began to realize that there was many things that any black defendant was not going to be the beneficiary of if the lawyer came out of Eurocentric legal education. And so what was particularly interesting to me is that in the area of victimization, on one hand you have the criminal law, and on the other hand you have the tort law. Now, if a white person is a victim of an action that you have caused, then they are the beneficiaries of both the criminal law and tort law, which means that, like in the case of O.J. Simpson, they can, on one hand, try to prosecute him, and then after they fail maybe to prosecute him successfully, if that's the case, they can turn right around and sue him. And that's what happened with O.J. He did beat the criminal case, even though they tried hard to convict him. But after that, they still sued him for wrongful death. And
right. So in other words, In other words, if you lose a criminal case, you have no basis to really sue somebody later on, right?
Well, yeah. Well, you see, this is the thing about it is, in California, where it happened, OJ. I mean, the family, the victim's family, certainly was part of trying to put him behind bars. But that still did not stop them later from saying that he wrongfully killed their daughter, and so they was able to do that, and they were able to get a judgment. Now OJ in turn, he ran off to Florida, where he should have stayed, because Florida has those kind of laws that protect people who have judgments against them from other people coming into Florida and taking their money. Unfortunately, OJ, for whatever reason, decided that he was going to leave and go back and play Superman, and while in Nevada, he ended up getting tricked and convicted, And so now that's where he is.
He thought Charlie Cocker was still alive, I see.
Well, maybe so. Maybe he didn't read current events, but he said he got enough time now to read, and to find out that those things did not happen. So, this is what the problem is. So here you have, on the one hand, you have criminal law, but then whites can leave the criminal law and sue under tort law. Now, on the other hand, black people, when they are victimized, for example, by the police, well, the police usually not going to be subject to a criminal prosecution, in the first place. So, and there's nobody really trying to drive those cops to be put behind bars. So, when black people sue, they usually end up getting hush money, basically a few dollars to keep their mouths shut. And so this is what has happened in terms of most blacks, is that they only end up getting hush money. Like, for example, the Central Park 7 ended up getting hush money, And so we haven't heard from them since, whereas on the other hand, you have people who try to put white people behind bars. Now, it's interesting because it should be pointed out, and I don't want to sound egotistical, but I do have to rely on history to prove my point. I happen to be the only lawyer in America who came out of law school and was committed to putting white people behind bars. And as a result of that, the only lawyer that who can say, well, I put the Howard Beach thugs behind bars, I put the Benson Hearst, Joseph Farmer, who got 33 years to life, he's behind bars, and I was on to putting Stephen Pagonis behind bars. Okay? Now, white people cannot see that. All right? Putting white people behind bars is going beyond the pale. They can't embrace it.
Well, I guess that's like a black police officer committing himself to arresting white people.
Yeah, right. That's it.
If you have one that openly admits this, or just openly practices this, he's going to get in trouble. Or
if the statistics show that that's all he's doing is arresting white people. You know what I mean?
Right.
They start looking at the numbers. And when they look at the numbers, they start saying, wait a minute, this is a far cry from what you're supposed to be doing. So with me, it was a far cry when I was supposed to be doing. All right? Now, the reason why I did it, because, you see, when I studied criminal law in law school, I also studied the rationale for punishment. And the rationale for punishment is that it's supposed to be a deterrent. So, to me, that meant that if we're going to stop black people from being brutalized, we got to start putting people behind bars.
Right.
And so that is what I started to do. In addition to that, I'm the only lawyer in America that ever got 2 special prosecutors, and demanded that they also replace the local prosecutors and also help put white people behind bars. And so this was just really too much for the system, but it was also too much for our own people because, you know, if you go back and look at it, you'll find out that black people themselves cannot view white people as criminals.
Right.
I mean, despite all that they do, they can't do it. And the only thing you got to do is look at the videotapes or look at the newsreel. You get a situation like what happened down there in Charleston, South Carolina.
Right.
This thug
That's what I was
Roof, right? This thug Roof went in the church, AME church down there in Charleston, and shot up the place, killed 9 people, and when the blacks got a chance to speak, they were begging for his forgiveness.
They couldn't wait to beg forgiveness. They couldn't wait to say, "I forgive you."
They could not wait to beg for his forgiveness, even though he never asked them for it.
He never asked for it. Exactly.
Right. No, right. He never asked them for forgiveness, but they couldn't wait to ask for forgiveness. And if you notice, when blacks get on TV, they always refer to these thugs as gentlemen. All right. So what I'm trying to say to you is that it's not like I have any friends in either the white community or the black community. Because most of what I've tried to do, black people are opposed to it. You know, I don't really have no real permanent supporters. You know, and many of the blacks who are around me absolutely refuse to support me. They find other ways of trying to sabotage everything that I do. All right. Now I'm gonna give you an example. I'm gonna give you an example of that. Sonia Bland was a matter of real concern for me. All right. Here's a young woman leave Chicago and get down to Texas, and when she get down there, she has not violated any criminal laws at all, and the cop does not like what she says or her mannerism or whatever the case is, and she ended up being lynched in a prison cell.
Right.
Now, to a lot of blacks, that may just be Sonia Bland because that's the way we've been trained as slaves. We've been told everything is personal. But the reality of it is that this was a class action. This is exactly what Chief Justice Roger Taney suggested that white folks should do to all of us. So whether it was Sonia Bland or Mary Blue, the reality of it is it could have been any of us. So I have to be as concerned about what happened to Sonia Bland as anything else. That's driving wild black. Now I'm gonna show you. I'm gonna show you the flip side of that. I started complaining to Chief Judge Jonathan Lippman some time ago about segregation in the legal system. And so what I said to him is that New York allows white felons to go into the practice of law. New York also allows white immigrants to go into the practice of law, but it doesn't allow black African immigrants to practice law, nor does it allow black felons to practice law. And so I filed a complaint with the Justice Department on that matter because, I mean, this is just rank discrimination and segregation. And so as a result of me filing that complaint, he filed and said, well, I'm going to have a statewide attorney discipline hearing. And it's going to happen in Buffalo, it's going to happen in Albany, it's going to happen in New York. And so the first one was in Albany, and that was on July 28th. Now, as I was driving while black, going up to Albany, I got stopped by a New York State trooper. And it was frivolous charges, but I was stopped. Now, after I was stopped, see, this is where the problem comes in. Even if you did not get killed like Sonia Bland, it still should be a concern of yours because a lot of other things could happen. You know, like, for example, in Ferguson, Missouri, blacks who were driving through Ferguson would be arbitrarily stopped and cited, and then have to pay for their driving while black through Ferguson. Now that is revenue for the town. So you have large numbers of blacks in New York who may survive being murdered by the cops, but they end up having to pay some money. All right, so there's a black tax on driving while black. So when I was stopped by the state trooper, he cited me for that. And so, he gave me the citations, and I took them, and then I went up to Del Mar, New York, where I was supposed to appear in court, and I did. And I talked to the prosecutor. The prosecutor talked to me, and he said, well, you can plead guilty. I said, well, I don't do that. I don't never plead guilty to anything. And so, and then I went before the judge, and the judge was irate because, you see, when you go in these little towns, they just simply operate like an assembly line. In other words, next, and you say guilty. You know what I mean? And that's the way they roll. And so, when he got to me, he was irate that I said, no, I'm getting ready to have a trial. And he went nuts. And he lost his composure. I mean, even white people came outside the courthouse later and said to me, what happened? Because this man went nuts. Now, what happened is that he knew that I insisted on a trial. And so what other people don't normally do, during the course of the colloquy between me and him, I took note of what I thought he said, but I said, I'm going to back that up because I'm going to demand a transcript later. I didn't say the same to him, but I called the court stenographer, and I said, look, I want you to give me a transcript of what he really said. Now, what he really said was you have a right to certain things. When I said, well, I want a trial, I want a right to a trial, that's when he changed up. Now, his present position is this. And this is important for people who are listening to know how you have to fight in legalese. We're talking about legalese and military science now, because there's only two things white folks understand. And so what I did, I got the court stenographer to give me the transcript, and she certified it. When the judge read the transcript, he didn't like what the transcript said. So he then writes me a letter saying, I meaning the Judge Ryan Donovan, I, Judge Town Justice Donovan, have all changed the transcript, and we're going to proceed from that. I'm saying, wait a minute, man, you can't do that. Because you see, what we have to understand in black, this is going back to South Carolina, but I'm trying to deal with by this example. Look, whenever you look at the conduct of police officers, you should have a penal law book in your hand. As you are observing the conduct and writing it down, later you should go back through the penal law and see what crime that the cop has committed. Now, in my case up there in Del Mar, the judge has violated Penal Law Section 175.25 of the New York Code and Penal Law Section 175.35 of the New York Code, and both of them can be found on my website, and the motion that I made is www.reinstatealtonmaddox.com. So the transcript and everything right there on the website. Now, see, this is where the problem is, what he got. I'm the kind of person, you're right, who look at what this deputy sheriff did in Columbia, South Carolina, and said firing him is not enough. Because my position is I want this judge in Del Mar, New York, behind bars.
Yeah.
Okay, it's on now. You understand what I'm saying?
Good luck with that one.
You ain't worried about it. It's going to be all right. All right. I mean, I may have some opposition one way or the other, from even people in my own quarters. But this is the reality. This guy has committed a crime. The same thing down in South Carolina. Now, this is how you have to do it. When you're watching what happened in South Carolina, right?
Right.
What you have to do is write all that down, get a South Carolina penal code, match up the conduct with the violations of the penal code, and then write the South Carolina Attorney General and say, I want an opinion as to whether this conduct was criminal or not. Now they got to give you an opinion, and their opinion got to be yes, this conduct is criminal. Once you get his opinion, then you proceed against the sheriff.
I got you. You know, I gotta have you back on. I gotta have you back on in the future because there's some cases I want to tell you about regarding that. But also, because we don't have a whole lot of time, but you know, any of you out there want to have a question for Mr. Maddox, go right ahead. Don't let me interrupt. But I do notice one thing, since you mentioned Sandra Bland, we do have kind of an alarming rate of officers going after attacking black women. And during around that same period of time, we had about 5 black women dying in custody, including Sandra Bland.
Right.
Which I thought that's
yeah. No, you're absolutely right. And I don't want to cut you off because I want you to continue, but I want to get this in. One thing that is going to bring me up to Buffalo very soon is the fact that they are now investigating Eva Doyle, who ran for lieutenant governor, and they're trying to put her behind bars. Okay, so, you know, this is the way they roll. I want to put that out there because it's real. And I don't plan for Cuomo or anybody else or any Negro Tom in Buffalo, preacher, whatever the case might be, helping Cuomo to put this woman behind bars. I want to serve notice on that. I mean, you can go ahead and say whatever you want to say after that, but I just want to put that out there now so that everybody's going to know that when you start playing with me, you're playing with fire.
I hear you. Well, listen, you, of course, know the story of Carrie Horn. As a matter of fact, I think you mentioned selecting her for an award a few months ago.
Absolutely, right, absolutely. And that's another case that I would be coming back to Buffalo to deal with. You're absolutely right. This is the most craziest thing in the world. This is the craziest thing in the world. And I don't plan to let that go down, all right? See, I'm one of those persons who look, when I practiced law, I wasn't worried about what anybody was going to do to me. I was concerned about whether they were worried about what I was going to do to them. You understand? Because that's the way that I roll, and that's the way that I see things. And this and what has happened to Carrie Horn is absolutely outrageous.
Oh yeah. Well, listen, I'm telling you, I'm letting our listeners know also because I recently interviewed Carol for a cable access YouTube show called Policy and Prejudice, and it just went up a couple of days ago. So check that out. It's about 40 minutes, and we go into some of that. And we talk a lot about what you're talking about today, what Malcolm once called the Black Revolution versus the Negro Revolution, because that seems to be what's going on. And seems to be what's going on in Buffalo. Okay. Right. You say it's going on in New York City. I think it's going on in Buffalo about probably 5 times worse. All right. But it is what it is, and that's part of the problem. I want to leave off on questioning you about Tawana Brawley, or whatever her last name is today. How is she doing?
Well, Tawana Brawley, is obviously, still battling the scars. And you see, this is the real injustice here. If people don't get anything else about Tawana Brawley, they need to get this. Tawana Brawley was never served with legal papers. So whatever Abrams said in terms of her perpetrating a hoax, she never had a trial on that. He didn't bring no charges against her. I mean, and many millions of dollars he claimed that she caused the state. Well, what happened to him indicting her on filing a false complaint or something like that? She could have been prosecuted. He didn't do that. Now, in the civil trial, Pagonis did not serve on her, so she was never involved in the case. Never involved in the case. Now, Negroes will run around and say, well, why don't you want to talk? Well, look, first of all, you ain't following my career. All right? Because I'm in charge of my clients, not Tawana Brawley. All right? Now, there are 3 things that you have never seen any of my clients do. Never. And people have gone to trial and watched me perform, but they've never seen 3 things. I never put a black person on the witness stand.
I heard you. I've seen you write that several times. Why is that? Well, because first of all, black people don't understand legalese. And secondly, they got and they will screw up, and they got a bad reputation. All right? So,
the last thing you want to do is put a Negro on the witness stand. I mean, that's
what's your name? My
reality.
name is Joe. I mean, my name is Ralph. My name is
yeah, right. Once they look at your face, it's over. All right. So I never gave any prosecutor the luxury of asking you any questions because I would never put you on the witness stand. Secondly, I would never ask you what happened because at some point judges like to ask lawyers, what did he tell you? I don't know. You know, like some people, well, why don't Tawana talk? I don't know what Tawana would say. I never asked Tawana what happened. What people got to understand was there's something called the attorney-client privilege, which I don't take benefit of. There's also something called the work product privilege. All right? Now, what that means is that I can go out and investigate your case and find out what happened without having to ask you what happened. And that's what I do. And that's what I did with Steve Pagonis. I busted Stephen Pagonis within 6 weeks after Tawana was raped. And New York knows that. All right, I got the whole skinny on him within that period of time. That's the way I roll.
Yeah.
I never asked clients what happened.
I looked at that documentary regarding because I went by because any accusation of rape, I go by what the medical experts say. The people from that hospital, what they said, there was a series of YouTube videos on that where they made the commentary. They said, yeah, something happened to her. She was almost dead when we found her. Okay,
absolutely.
And they went on and on. I said, okay, well, now we got a case. Also, all these other people talking about, you know, oh yeah, well we'll go so far as to say she beat herself and scribbled feces on herself and wrote some racial epithets on herself. No. Nobody does that.
Nobody does that. But she didn't do it.
Right. Well,
and you see the thing, and people got to realize, well, first of all, everybody that examined Tawana, I did not know. There was a gynecologist up there in the Mid-Hudson Valley area that I called and asked that gynecologist who I never met before. I said, will you go and invest and examine Tawana Brawley? I didn't know this person was Adam House Cat. I couldn't even represent the person today if she was in a lineup. And so as a result of that, the gynecologist was the one that put her in the Westchester County Medical Center. Now, the last time I checked, the Westchester County Medical Center is a white hospital. Now, what the Westchester County Medical Center said, and they put it right there in the report, she had been raped. That's what they said. Now, what else do I need?
You don't need anything else. But listen, we're going to leave off from here because we're running out of time, and I would definitely we're going to have you on in the future, and I want to thank you very, very much for coming on. And thank you, listeners and callers.
From 1111, Attorney Maddox, is that your line that's open?
Yes, sir, Brother Sharif.
All right. Glad to have you. Welcome to THOR Radio Network. The acronym is actually the House of Restoration Ministry, so we restore not only the economics of many people from different diversities and universities, we deal with other issues in terms of the mindset, heart, and spirit, which is something that was incorporated from my own personal experiences. But we welcome you here. A lot of excitement. The matriarch of this network, Yama, she's from New York as well as I am. I'm from Manhattan, Harlem, right next to City College. So I'm on Convent Avenue. And you are as well from New York, so there's a lot of history there that's in common, at least geographically, territorially, that we share. But welcome to the show. You heard a clip of yours. If you would, just introduce yourself, tell us a little bit about you, and then we'll get into the various subject matters and topics that we have to get to quickly.
Well, I want to first say that particular clip really took me down memory lane. And it was what is called refreshing your recollection. and so I'm very happy to have heard it because I suppose in in my practice, and also not only in my practice, but just in terms of my involvement with black people, that there have been, many roads that I've had to take to try to get to the destination that we were seeking, and that a particular, clip was reminding me of so many different struggles that we have been involved in over the years. I have practiced law here in New York City, starting in Harlem, and continuing to practice not only in the city of New York but in the state as well since about 1974. And so I have gone down many roads and have had to confront many enemies during that period of time.
Interesting. Many people would like to at least spend a couple of minutes on some of the high-profile cases that you were involved in and spearheaded. A lot of interest in those, I'm sure. You'll get some of the run-of-the-mill questions out the way, and I'm sure the rest of the interview will be somewhat different than what you experienced, but we're not going to spend a lot of time asking you the same questions that's been answered, and people out there can definitely listen to you in length on YouTube and hear a great variety of different atmospheres and different interviewers who extrapolated that information from you. But I would like you to touch on a couple of the high-profile cases because it's going to allow us to segue into some of the current events that's going on, and I definitely want your perspective on it. But tell us a little bit, if you can, about the Tawana Brawley case. When that case was out, I think I was in, high school. It was one of those, at least to my recollect, one of those big cases that at that time I was in school, you kind of was looking at other cultures as if, really? So tell us about Tawana Brawley, a little bit about that case. I listened to a lot of the information that you put out about it. Some of it I read, and then some of it I was quite surprised about, I didn't know about. And one of those aspects were that I believe the district attorney or prosecutor that was involved was actually implicated by you as being a participant in the alleged crime. And you spoke about the grand jury who reached that same determination. I found that mind-boggling. As well, the last thing that I found mind-boggling was there was a subsequent lawsuit civilly, I believe, against you and maybe Tawana Brawley, because you spoke about how there was a judgment out there and how this prosecutor or district attorney, due to, I guess, some allegations made with respect to the defamation, I guess, she is under a judgment that he obtained for a great deal of money, and she's unable to benefit economically due to the fact that she would have to pay him those funds. So if you would just touch upon Tawana Brawley in your own words and your own descriptions, and tell us a little bit about that and try to address those two questions that I posed, or those two statements.
Well, Brother Sharif, I will do that, but I do want to give the audience a bird's eye view of my perspective and my approach. I really probably handle more pro bono cases than anybody else in the United States. And I did it because I was attempting to deal with legal classifications instead of legal compensation. And when a lawyer can abandon the thrust of legal compensation and get involved in legal classifications, it takes you into a whole different arena. And so, as it was with me, and I'll go back and talk about some of these things, and I will certainly deal with Tawana Brawley because she certainly fits in one of those legal classifications. But I would just, for example, give the cases of Howard Beach and Yusuf Hawkins, who was murdered in Bensonhurst, and Michael Griffith was murdered in Howard Beach, as an example. I saw that, for example, as an approach to ending. I just didn't take the case for the sake of taking the case because I represented them pro bono. I didn't get a dime from it. But I saw the bigger issues of the right to travel in New York, which was being impeded by white vigilantes. You couldn't walk or ride in certain neighborhoods if you didn't fit that description of that neighborhood. So I thought that was wrong. So I couldn't wait around for a person who had the money to come forward to say we want to end that, because black people don't roll that way. We still suffer from the idea that freedom is free, and it is not. And so I couldn't wait on black people to get their heads together before I solved the problem. And the only way I could solve the problem was taking the case and ending it, as we did, along with cases like Bernard Guest, who shot 4 innocent young black men on the subway with a weapon and received virtually no punishment from it. So you had the state and the city actually sanctioning white vigilantism, and my approach was to bring that to an end. And fortunately, I believe so far we have done that. So that's in one area where I saw things. I got involved with the African burial ground because I thought that we should respect our ancestors and let them lie in peace. And so when the mayor of the city of New York was hoodwinking blacks because he was actually being sponsored by a special interest group called FIRE, which is an acronym for Finance, Insurance, and Real Estate. I took that on, and we ended it. And what's ironic is that today that's become a major tourist attraction in New York, while at the same time I have been banned, and it would never have been a tourist attraction without my involvement, because New York City wanted to excavate and erect a federal building at that location. And so, obviously it did not sit well with the mayor, who was under orders from FIRE to hoodwink the black community, and eventually erect the federal building, which he was not capable of doing. So when I say that to say that, that's how I really approach the law, not in terms of compensation, but in terms of the causes that were irritating our people at that particular moment. Now, Tawana Brawley, to me, related to the slave codes, and so I saw that as a real problem, because even when I first got here in New York, I realized that black people could not file complaints against white people. I started practicing law in Harlem at an organization called Harlem Assertion of Rights, which was a poverty program. And I chose to start off as a poverty lawyer for the simple reason that poverty is the main issue in the black community. And so I felt like as a problem solver, I didn't need to be in some government building prosecuting blacks, putting them behind bars, but actually deal with the issues that affect to many of them going to prison in the first place. So that's why I started out as a poverty lawyer. And then as a poverty lawyer, I began to find out that people who came to the office, would want to file complaints against whites. And the district attorney instead would say, well, you could file a complaint, but we're going to have to call the white person to see if they want to file a cross claim or a counterclaim. And And so, obviously when the white person was given that option, they would say, yeah, I do. And the end result would be that the prosecutor would then tell the black claimant that, well, we can only prosecute one of these two cases, and we got to avoid a conflict of interest, and that's because we are bound by ethics, and therefore we've chosen to prosecute the white person against you. So, and ultimately the person who filed a complaint in the first place would end up going to jail. So, that's what really brought on the interest of mine in Tawana Brawley, because, here was a 15-year-old girl who had been missing for 4 days. And in the process, when she was asked where was she and who did it, she uttered 2 words, white cop. That's all she said. And, of course, from there, all hell broke loose, so to speak. And so that's where we are now, only because she said white cop. And, and ultimately I got the case. I chose to take the case after the black community had promised that it would stand behind me in this case, because this is not like a garden variety type case where you're really up front fighting slavery up front. You can expect that all of the law enforcement agencies, all of the special interest groups, and others are going to rally behind whites, and you're going to have to end up fighting them. And that's what I had to ultimately end up doing without the support of the black community, which ran for the tall grass. But that's not a concern of mine, because that's one of the things you expect people to do when they are unorganized in the first place. And so we are now facing a situation where a young woman who was told by the world that she was nothing, and now had become a nurse and has a daughter of her own, attended Howard University, and did all the things that the state of New York says that she was not capable of doing. And ultimately, she is now settled down with a judgment which was not valid from the beginning, because you don't have to tell a landlord tenant clients that if you don't get served, you don't owe anything. And so Tawana Brawley was never served by Stephen Pagonis. Her name does appear on the complaint, but a name appearing on the complaint means nothing if you've never been served, because the state has to first get personal jurisdiction over you in order to render a valid judgment against you, and that never happened. And so that's why I now call that judgment the Fugitive Slave Act of 1850, which was real, because back in 1850, if we broke out of slavery and got to the North, the Fugitive Slave Act said that people could cross the Mason-Dixon line, seize us, and bring us back to where we belong. So that's why I call this the Fugitive Slave Act of 1850, because absent total constitutional protections, Tawana Brawley now has to share her money not only with her daughter, but with this white racist who raped her in the first place. And so nothing has changed with me, because I said from the beginning he was a rapist, and I'm still saying he's a rapist. The only problem that he has now is that he can't say anything about it now. He can't complain because I beat him in Dutchess County. And so the object of defamation is not to seal the lips of somebody who's innocent. And so I'm innocent, and therefore, I continue to go after him, and I will continue to go after him until such time as justice is done.
All right. Well, I appreciate that. I guess I would have one more question to add into that. What is Tawana Brawley doing today?
Tawana Brawley is residing in Virginia, as I said before, because of the fact that she is required by law until she can get counsel, and no lawyer I know of yet who's willing to associate with her and the lawyer who is willing to associate with her has now been banned from the practice of law for 25 years, illegally, however. That's where we are. She still has no legal protections, and we can't find any lawyer who is ready, willing, and able to defend her, and I can't find any black group in New York, including the groups that I was associated with, who are willing in any way to defend me or Tawana Brawley.
Okay. All right. You speak a lot, and I appreciate that update for those that had an interest in Tawana Brawley. We speak a lot in a lot of your clips, and I'll be honest, I've listened to most of them, and they're very interesting. And we understand that you were an attorney at law, one of the few, for lack of a better word, blacks or African-American attorneys. In listening to some of your audios, I understand that you were one of 3 in law school in the state of Georgia.
Mm-hmm.
And you speak a lot about a lot of the corruption, backdoor deals, discrimination, so-called white supremacy. You speak about history in terms of laws that were made for black persons or black people that are still around, if not in theory, somewhere existing in law or incorporated into some statute or code or some act. And, you know, as I listen to a lot of the situations you've met head on, and hats off to you, you've done a great job at attacking certain dysfunctions, for lack of a better word, in the legal society and that system. When you decided to make that commitment to go into the legal society as an attorney, tell me what your aspirations were. What did you intend to do? Did you just want to go into it because there were not many of your so-called color in that arena? Did you want to go into it for the title of nobility that comes along with it? Or did you want to go into it to make a change for the conditions that you were exposed to in your rearing?
Well, you know, that's a great question. However, I'm going to answer it hopefully succinctly, but I think it is a great question because I think we are the products of our own environment, our own experiences. And so I don't think I'm any exception to that. And I think, you know, I certainly have to give great deference to my parents who really helped mold me and who never cautioned me about confronting Jim Crow. And I think that one of my friends who went to high school with me in John's Student Nonviolent Coordinating Committee and was there with many of the greats such as Kwame Ture and Abdul Alamein and others, as well as Marion Barry. And you know, I remember in 2010 we were holding a meeting at the Freedom Party in Washington, D.C., in which he was a councilman in Washington and also the architect of the Civil War Museum. You know, he told the audience that what he respected about me was that unlike most people who were in the Civil Rights Movement back then, I was the only person that actually went back to my own hometown and confronted white supremacy, Jim Crow, and all the other evils right there in my hometown. And you know, and certainly with that, you know, my parents, were not vocally urging me to do what I did, but they certainly did not stop me from doing it. Because at that point they recognized that's who I was, and they certainly was not opposed to it. You know, of course, parents always have fear when you in the Jim Crow South and behaving as though you were a black man. But I think what is more important is that I actually started in segregated schools, and in segregation, there were not any real legal restrictions. For example, when I started school, I was about 4 years of age. And actually, there were no restrictions on 4-year-olds going to school. And you have to remember the second part about segregation is that many times you would be in a classroom with second graders, third graders, and whoever. So you could sit there for the first year. If you were alert enough and acquired those skills, you would actually learn things right there in the first grade. That will put you now in a position to go to the fourth grade. That's just how things were. So it benefited me because it enabled me to read newspapers at an early age and journals at an early age. So I was reading the Atlanta Constitution, Atlanta Journal before I was 5 years of age. And I was attracted by the Korean War or the Korean conflict back then, and I was reading on a daily basis. And and then as time went on, I became aware of the Boy Scouts, and then they had this book, Boy's Life. And I can recall in it, I would read about these military academies that a lot of young whites were going to. And obviously we didn't have any military academies of our own, but I was inquisitive about what were they being taught. So, back then we didn't have these zip codes and all that kind of stuff that what people could really track you. So I would write a letter, from my address in Newnan, Georgia, and said I was interested in attending the academy. They didn't know I was black or white. And I would like to know, what advice you could give and what kind of curriculum you had and what brochures you had and the whole bit. So I began to really expand my definition of the world right then and there. And then, we had the Portermans, A. Philip Randolph Porters, who would come through the town every week and bring these newspapers from places like the Pittsburgh Courier, the New York Amsterdam News, the Chicago Defender. And so, at a young age, I was like just sitting there and reading this and visualizing what the real world was about beyond Newnan, Georgia, where I was growing up. So I think that was very important to me. And then because we didn't have cable television or anything like that then, we did have court TV in the sense of the courthouse being a place where people would go and watch lawyers perform. That was form of entertainment back then. And so we had a lot of great lawyers, black lawyers, right out of Atlanta and Albany and other places that would come to Newnan and try cases. And, it would be like us sitting there watching a Joe Louis Max spelling fight. And then raving about how great these black lawyers were. And so I think a lot of that really propelled me to really want to get into the legal profession.
Okay. That's great. Let me ask you one more question before I get into some more customized subject matter. Al Sharpton, I know you had, or believe you had, represented him in the tax matter, and he was very close and became a household name, at least in part, due to the Tawana Brawley case. He's advanced, I guess, some would say. He has a TV show, I guess you would call it, or news show. As of late, though, him and Jesse Jackson, which I'm sure you know, pretty much the people have turned their back on him. I feel it's warranted, in my personal opinion, being that I don't see much of an accomplishment of those so-called leaders in what they say they're trying to accomplish or trying to achieve and what they have actually achieved. Tell us a little bit about Al Sharpton and what you think about his current stature and what it was back then, whether there's been any maturity or whether things are just the same or whether he's just really a mouthpiece for what people may call the other side.
Well, one of the things that I did, and this was roughly about 1985, 86, when I first became particularly aware of Al Sharpton. I mean, there were certainly news reports. He was certainly on some white radio stations back then, but I didn't really know him in terms of the black community until about 84, 85, really, when we started the school case here in New York, where Mayor Koch had appointed Robert Wagner as the school's chancellor, and I was able to go into court and bring a lawsuit that actually stopped the mayor from naming Wagner as school's chancellor, and because I didn't see any educational benefits to that, in addition to the fact that the school's chancellor in New York until that time had always been white, and a white male. And so the benefit of the lawsuit is that it put the mayor, that is Koch, in a corner in order for him to come out. He couldn't necessarily, or he didn't necessarily, want to acknowledge the black presence, so he decided to compromise and appoint Anthony Alvarado, who became the first Latino school chancellor in New York. And then, obviously, after that, there were some blacks who came afterwards. So we sort of had a fix on that in terms of changing the complexion of the city as related to education. We certainly had brought in the congressional hearings on police brutality, which changed the complexion of New York City in terms of the police department, especially the head of the police department, where you had Ben Ward, who became the first, and then you had Dr. Brown, who I believe is now back in Texas somewhere, who became a police commissioner as well. So, I mean, in that area, a lot of those little things happened. But the only thing I really remember about Al Sharpton was the school's chancellor situation. And we didn't work with him, but, I was aware of him from that. But what really became of great interest to me is that one day I recall going to the offices of Louis Clayton Jones, who was a very prominent lawyer here in the city, who is now deceased, and Clayton Jones and myself had worked together on the Michael Stewart case, police brutality case, police murder case back in the 80s. And I remember on this particular day, Clayton saying, Alton, Al Sharpton just came by the office, and like to me, I'm saying, oh, so what, And so he said, I can't believe that Al Sharpton. Now this is about 85. This is after Jesse had run for the presidency, and he said, I can't believe that Al Sharpton did not expand beyond Jesse. I said, well, what do you mean by that? He said, well, Sharpton is more gifted than Jesse. And, of course, I didn't know anything about Al Sharpton, so I thought Clayton may have been out of his mind for saying it. But, over a period of time, in 1987, at the House of the Lord Church in Brooklyn, there was a group of about 100 activists that met together that day, and the question became who was the number one menace to the progress of black people. And everybody in the group except myself said it was Al Sharpton. And I said, well, I hard for me to see that logic because at that particular time, Roy Ennis was the one that was getting most of the coverage. And I said, I don't know how you could jump over Roy Ennis and get to Al Sharpton. And so it was at that point where I basically said to the group in Brooklyn, I said, the one thing that we have to become as a people is ethical. And getting rid of Sharpton is not going to solve our lack of ethics in the black community. I say because the reality of it is this is just a selective matter that some of you feel that Sharpton may be the number one problem, but right now he's not. Obviously, Roy Ennis is getting most of the attention, and if we were going to go after anybody, it should be Roy Ennis. And so as a result of that, I began to see, Sharpton getting closer to us. After that, obviously, to save himself. And so that's how our friendship, in quotation marks, started, roughly from the House of the Lord church encounter, as well as Lewis Clayton Jones giving a reference to Al Sharpton.
Okay. Well, I appreciate that. I want to transition and speak for a few minutes about the issue of race, because I know, many people had questions, and I'm of the mindset I see a lot of the deceptive media. I see the instigation. I see the propaganda machine, especially of late. We had the Pope come out and tell everybody that pretty much the second coming of Jesus wasn't going to happen, and he probably was drinking a little bit too much, and that their tenure would probably be less than 5 years. We've had a lot of scandals in the Christian church, a lot of pastors involved and engaged in activities unbecoming of their title of nobility. Also, we're seeing now the media put black and white and brown separated by Christian against Muslim. So the new thing is the Muslims are coming, ISIS is coming, Al-Qaeda's coming. They're walking across the desert. They got camels, they got cows, they got helicopters, they have jets. I mean, they even have the nerve to show this so-called ISIS group. They showed a clip on TV, and I just started laughing. They had military tanks, and I'm like, well, how does a militant group get military tanks? I mean, they look like our military. But my point is not that. My point is the race issue really an issue of the mind, an issue of legality, or is it just something that people use to cause division, or in some instances for some to benefit financially from, in your opinion?
Well, I would like to start that by just sort of emphasizing something else that you said, which made me probably more sensitive to race than others, is the fact that I, among other things, had various experiences, but I also attended or chose to attend the University of Georgia Law School, and I had a real reason for doing that, in that the University of Georgia was founded by the leading architects of the Confederate States of America, and that is the Cobb brothers. And so I felt as though, from me, it was better for me to attend the University of Georgia Law School than to attend Harvard, because it seemed like, our problem was more racial at that particular time, and Harvard was not going to really address it. If anybody was going to address it, it would be somebody like those at the University of Georgia. So I chose that particular institution, and I was not disappointed in terms of, what I saw. And basically, what I can point out is that the issue is probably much bigger than race, but I think we feel race because the law schools actually promote racism. And so when you have the legal thinkers going to these schools in which black people are pretty much defamed in terms of the school curriculum, that you're going to find that as a result. Now, I think the issue is somewhat bigger than that, but I don't think you can discount the legal training of lawyers in terms of what they see as solving these problems later, as the judge did recently in Cleveland, where you had over 100-some bullets spent on 2 unarmed persons. And at the end of the day, when the trial ended last week, the judge found that Brelo was reasonable in doing what he did, and that is unloading his clip and then reloading against the 2 unarmed suspects who also had to duck and dodge 100-some other bullets from other police officers. So I think that's a real problem right there. It may be an intermediate problem, but it's still a real problem because these are the kind of people that are affecting our lives. You know, I think that when you look at closer, and you talk about, the way that Muslims are treated or depicted in this country, you go back to the Christian Crusades, when you realize that our jurisprudence, meaning in this country today, is actually based on the jurisprudence from ancient Egypt of 4,000 years ago, and then you can begin to say, well, this is a matter of trading places, where those of us who were at the top and now find ourselves at the bottom, and those who were at the bottom 4,000 years ago and in caves are now at the top. So I think you can look at it that way. But as I said before, I think an intermediate problem, though, is the way that these lawmakers are taught in these law schools. And at the time, I remind people that law school was first established in this country. We were all still in chains. So these law schools were not established to give any rights to descendants or to Africans. They were formed in order to maintain the institution of slavery, and since that time they have reluctantly made a few cosmetic changes in their approach.
You raised some interesting points in a few of them that I like to address, and I was going to get to them anyway. I'm going to get to the police situation last. I want to bring up something that you mentioned, not only in some of the clips that I was able to watch, but you speak a lot, like you just made the comment about the system, the law schools that were predominantly white. You mentioned in one of your clips about the U.S. Supreme Court does not advocate natural law. I heard you also mention about one of the most common, I guess, topics in terms of case law that the so-called black society speaks about is the Dred Scott case. And I read about that case. I had an alternative show speak about that case, and it's sort of like the Nikes of the conscious community. Okay, it's in style speaking about that case. I want to get your comment on it, but I want to give you my perspective on me looking at the Dred Scott case, and one of the things that I heard that interests me. I listened to that case, and I heard, and I don't know which judge it was, but I heard him say that if a black man, so to speak, wants to be a citizen, he must get naturalized into what we think is a country, but the United States is a corporation. So that part, and my position has been, since listening to these cases, Attorney Maddox, is that it seems like, from what you're telling me, the corruption, the flight towards so-called black people, the supremacy issue, the system, by and large, But then you went historically and you plucked out the fact that the tables were turned because there was a capacity, I guess, or a position in history where you're insinuating that we were the creators of many of these things, and it was taken over. And in my own opinion, in translation, through the Dred Scott case, they built them a golf club called the U.S. Corporation. And they had founding fathers that I believe looked like them, didn't look like many of what you call us or blacks. And it seems like through that case, although a lot of black people talk about it, it seems like this man has said in many instances, all the way up to the Supreme Court, which I feel is the highest court for the corporate United States, meaning they deal with persons, 14th, 13th Amendment, however you want to cut it. But it seems like they've built their own private system. And the tone that I heard in that case by those justices is simply, if you want to be a part of our system, you have to get naturalized. Well, then I'm listening to your clip, the one that I played that you said took you down memory lane. You spoke about sovereignty and the indigenous cultures, and you spoke about tribal rights and things that I really like to talk about. If that system is in the way that in the manner that it is described by you and others, Attorney Maddox, then why are we continuing to force ourselves to be a part of it?
Well, I think that probably would have been a great question to have raised around the time that Lincoln had proposed us returning back to Africa, or maybe the, quote, Dominican Republic or somewhere else outside the United States. And, and Liberia being set up, for us to have a return back. But obviously, most of our ancestors apparently appeared as though they believed that our lot was here. And so,
right.
Whether they were accurate or incorrect, it's hard for me to undo what they decided to do. And, I suppose now would be the question, is it too late for us to accept that invitation? But if it is too late, then we're where you said we are, and that is trying to break into something that people have said we should not be a part of in the first place. The other side of, Dred Scott, and I think it's some very interesting aspects of Dred Scott, but the thing that I think that we have to take from it, and many of us are fighting it, and that's where our problem is that this country perceives us as a class, and that's what basically Taney was saying, that we were a class, and a class without rights, and that there were actions that had to be taken against this class. Now, to me, the point is that if that is the case, then why are we disorganized as a people? Because if they have said that we are a class and we accept that, or as many of us do accept, then why are there so many other people who do not accept it? That we are a class. I mean, why don't we just be under 1/10? And then in Plessy versus Ferguson, 1896 case, they basically put the hammer on any exceptions by saying that one drop rule rules. And so anything else they didn't want to talk about. So, I think the bigger question now is, even before we get to whether we should be breaking in or breaking out, is the first question is, why can't we just be a class? And why can't we embrace ethics as a part of the glue that keeps us together? Because I have an acronym that over the years that I have developed into believing, may be something that's necessary for us as a people, and that is because we do need help. The ancestors put me in touch with what help really means, and the acronym is that HELP means history, ethics, logic, and philosophy. And so if that is the case, then why can't we just simply say naturally that we're going to look at history, we're going to look at ethics, we're going to look at logic, and we're going to look at philosophy, and then decide whatever, our best course of action, that we should pursue that. So, you're probably right that, we should be taking a look at other things, but it seems like whatever we take a look at, we all do it in a collective fashion, because that's the way the game is run, and we are not collecting whatever we do. We're not going to succeed anyway.
Interesting. When you mention Liberia and Africa, there are many people of the mindset that this is home. Why, when it comes down to so-called blacks, there's always an exodus location to where if you're not happy here, go somewhere else, where for some believe that this is home, and most of the people taking that position are visitors or immigrants. Why should they have to leave? What's your perspective on that?
Well, I think one of the things that's missing in this equation is the fact that there are a lot of people who rightfully do believe that this is home, and they rightfully believe that because they have spent all of their chips in the United States. And not only have they spent their chips here, but they have also saved the United States various times from its own annihilation. Now, the question becomes, those persons who believe that, why are they not real proponents of our history? The big thing is, when other people come to this country, they should be given an exam when they come in this country, but their examination should be on black history.
Right.
A substantial portion of anybody who comes to this country should be on black history, because the only way the other people are going to come in this country and respect us is to know our contributions to building this country in the first place. So this great nation that everybody say that they want to benefit from should be first and foremost aware of the contribution that we made to make it a great nation.
Okay, I totally agree with you. Now, that segues me into another topic. You spoke about the United States being a misnomer. It should be the United Nations, and that's one of the points I took glee in, is that I believe it is a United Nations. I believe there are many nations here that don't have the problems that so-called black people have, because they operate in that national capacity. And a lot of times when we speak about blacks, I think sometimes it hurts rather than help, because it invokes so many memories, many of which and much of which some of us in this generation haven't experienced, although we give honor and respect to those that may have. But how long do you think, or how long do you feel, Attorney Maddox, that we talk about the history without advancing and making life better? I see the judicial system as being probably the biggest failure that I've ever seen, and I'm not an old man, but, we deal with here the other side, and I know you've been within that, and that's why I was of the position that I wanted to have a different discussion rather than talking about a lot of the plights. We need to talk about the system, and you spoke about the system in very intricate form. And you said pretty much what everybody would get is that it's not reliable. It's defective, it's broke, it's discriminative, it's racist, it's abusive, it's unreliable, it has no rhyme or no reason. These are all the things that many of my listeners have come to the realization of. And when I say my listeners, that would be black, white, and brown, because one of the philosophies of myself on this show is that when we're dealing with economics, I have all walks of life, all so-called ethnicities. And they all suffer from that. Although some may pay a little bit less tax, they all pay taxes. Although some may, pay a little bit less of an interest rate, they're all paying an interest rate. Economically speaking, and one of the things you said I love was that you said everything about the U.S. is about commerce. Give me your perspective on that.
Well, one, when we deal with the area of commerce and its significance, we have to go back to the Iroquois Confederacy. That was a group of nations who were indigenous to this land, who were trading some 200 or 300 years ago with the colonies. And why that is important is that as they were trading with these 13 different colonies, the Iroquois Confederacy saw themselves as a nation, and many people believe that they were the forerunner to the United Nations. And so in dealing with Benjamin Franklin, who was the Indian Commissioner for Pennsylvania on Indian affairs, the Iroquois Confederacy said, look, we have a problem with trading with you because, and you got to remember back then, that kind of trade was very important. We talk about international trade now, but, people have to go back to where this country was formed from to put this whole thing in proper perspective. I mean, nobody was trading at that particular time in all of these other nations of the world. So now you're talking about 13 colonies dealing with the Indian population, quotation marks, and in dealing with that population, the Iroquois Confederacy said we're having a problem because you have 13 colonies, and we're just one confederacy. And it's hard for us to trade with 13 colonies under your concept of states' rights. Because we got to deal with 13 colonies. Each one of these colonies can make their own laws in terms of commerce. We're not getting ready to go anywhere. And so, we propose that you adopt federalism as a concept in which when you are dealing with your fist, you recognize that there should be one set of laws. But when you're dealing with your fingers, then you can have 13 different laws because that's states' rights. So the idea of federalism really came out of the Iroquois Confederacy, and the notion of commerce being at the centerpiece of American life really came out of that as well. And that's why commerce is important, and that's why this is a system of federalism, and that while you had certain states' writers even back then, but those who really ran this government understood that there has to be one set of laws when it comes to commerce, and so that's my reference.
Okay. Many will say, and you mentioned, the 13 colonies and the 13 set of laws, different set of laws. And, one of the cliches that I use around here is the 50 corporate plantations. But I'm going to go a step further when you say government. And I want to address this with you for enlightenment purposes. Now, a lot of people refer to the system as government. Now, and I've always been a little bit confused about government. And I like to incorporate your issue that you've experienced within the legal society, and we call them government. I usually call attorneys public officers or officers of the court. To me, creates a nexus between you being a part of that government. But I wonder, when I look into how they treated you, what they did, you mentioned also the law schools, that they were predominantly white. How can we have indigenous people here with certain cultures, and how can we have multiple nations, then have a law school that is private through a private association that will only allow you to become a student in that law school if they want to? And then they've created a system that we call government, and the attorneys are trained to be a part of that, And that system, those laws that they created, inclusive of their Constitution, drafted by their founding fathers, become binding upon everybody in this country. Now, and then they turn around and let you go to that school, Attorney Maddox, and then only to just terminate you at will. Does government do that? And is that really government?
Well, you actually you said it correctly, and I can just cite this as an experience because that's exactly what happens. Termination at will, if you so to speak. And if you find out that certain people don't fit the profile, you can terminate them at will. And I learned that as a matter of fact when I was going to the University of Georgia Law School, because after I had been there about 6 months, it became quite clear to everybody at that law school that they had made a mistake in admitting me. Because what happened was there was a confrontation between myself and one other white law student in a class of 150 people. And this particular law student was citing was citing a case called the Chicago Buyers League case. Now, the only reason why we were really discussing that case is because the law professor was from the University of Chicago, and he was starting out teaching property law at the University of Georgia, and instead of a traditional textbook, because most of these books are basically traditional, but he was teaching property law out of a progressive textbook. And so in a traditional textbook, we would have never been in there at all. We just would never been there. We wouldn't have been there for Shelley versus Kramer, where the Supreme Court ruled that the unconstitutional land transfer was illegal. We wouldn't have been in there at all. So we were not represented. The only textbook we were represented in was the criminal law. I mean, really. If it wasn't criminal law, our name was never mentioned in none of these other cases, or maybe constitutional law. So this particular law student, instead of using the word black or Negro, he said these niggas. And so I'm sitting there, in this classroom with 150 whites, and he said niggers. And so, to me, this was just absolutely unacceptable. So I stood up immediately and went into my bag because I also grew up in Georgia, so I knew how you have to deal with white folks. You have to make them think you're out of your mind. So when you decide that you want to protest something, they got to say, well, that Negro is crazy. So I jumped up knowing what I had to do and told him that if you say that again, I'm going to kick your rear end. But I didn't use the word rear end. I used something a little bit more colorful than rear end. And so he looked at me shocked, and the other students, 150 of them, looked at me shocked. So I said, well, I better repeat this again. So I said to him again, cracker, if you say it again, I'm going to kick your rear end. And, I mean, everybody just froze. And it was like, I don't think I heard that, But when they finally came back to their senses, 150 students went to the dean of the law school and said, this man got to get out of here immediately. And so, the dean said, well, we just can't kick him out right like that. So the student said, no, he has to go immediately. So the dean apparently told them, well, let me work this out. So he then, in turn, called me in. I didn't go. And he called me 2 or 3 other times. I didn't go. And then finally the other black law students convinced me that I should go, and I did. And I stated, my position to how I felt about him and the whole law school experience. Now, Professor Eggy was my professor. He's from the University of Chicago Law School, and he called me into his room, to his office, and said, Maddox, I think you have to leave law school. And I said, what do you mean? He said, well, I know you're a good student and all of that, but I think you get ready to waste your time here. I said, how am I getting ready to waste my time? He said, well, Dean Cowan, who was the dean, who said that anybody who teaches you law should get your exam book and then turn it over to him. And he was going to grade you himself. And he said that, this is bad news for you. And so you are absolutely right. And now I resisted for about 3 weeks, but then ultimately I came to my better senses. I said, I better get the heck out of here, And so that's the reason why I was able to go into another law school, because as he told me, look, if you leave here, no other law school in the nation is going to allow you in. It's one and done. Once one law school said you're unfit, it's one and done. So it's best for you to leave and then start afresh in another law school. And that's what I did. And so you're absolutely right. It's termination at will, just like employment or anything else. And so it had nothing to do with due process, nothing to do with the Constitution, anything else. It's just termination at will. And like you said, it's a private corporation doing their own business.
Okay. I'm glad we agreed on that, because that clears a lot of things for someone. And I want to say that I honor and really respect the fact that you went through that, but then I look at the generation now, which includes the latter part of my life and the beginning of my children's life, and I don't want them to have to repeat those stories. I want them to figure out, just like you and I have agreed, that these are private corporations. This is why I just don't understand. On one side, we can talk about nationhood, nationality. We clearly can define and agree that the tables turn. Speaking of indigenacy, we can clearly define the history that's been twisted around. But then when we talk also, it becomes confusing, because we talk about Exodus. We talk about going to Africa or going to Liberia or leaving here. So it becomes confusing to most of, even a lot of people of my generation, and then the children. And I want to segue into, you mentioned the fact that we were only mentioning criminal cases because it seems like we forced ourselves into a system that was not made for us. It was predominantly black. You were treated just like anyone else, unless you was going to come into the system and maybe bring them more business, which I don't think was your intention, and they seen that. But when you experience those things in lawsuit, was that not a prerequisite to what your future would hold, being in that environment or society or occupation? And if you were to go back now, would you have become an attorney if you had to do it again?
Oh, yeah. Well, see, I would have, but I think people have to also look at my background, which I certainly don't have the time to divulge it all here. But I will give you just a small snippet of what it was. When I graduated from high school, I chose to go to Howard University, which was at that time called the Capstone of Negro Education. And the reason I chose to go to Howard was because, one, it was, quote, the capstone of Negro education. But two, I really wanted to get into the Library of Congress, because before I graduated from high school, I kept hearing people say, all the knowledge of the United States is in the Library of Congress. And I said, well, if that is the case, I really got to go and study slavery, okay, because that knowledge must also be in the Library of Congress. And so slavery to me has to mean more than just the 1863 Emancipation Proclamation. It has to be more entailed. I must understand how we became Negroes in the first place. What were the techniques that we used and all of that. I said that has to be in the Library of Congress. So in the first year at Howard, I tried to use most of my time to make sure that I was still there, because that became a real problem to me, because my mother had said that you don't have to work at all when you get ready to go to college, because all of your college payments have already been made. I mean, we're able to pay whatever it is, so you don't have to work at all. The only thing you have to do is go to college. However, and my mother was a strict disciplinarian. She was a beautiful woman, but she said, you must never return to Noonan, Georgia as an educated fool. And I said, well, what does that mean? And how do I try to avoid becoming an educated fool? And so I had to try to work out in my own head how you do that. And what I realized was that I could not really partake of Howard University. I had to be enrolled there because I had to get a degree, and I had to try to go to law school and all that. But I just really couldn't not become a part of that system, because if I got caught in that, I may become an educated fool. So I always talk about this with Kwame Ture, who was a classmate of mine. Well, a schoolmate, really. He was before I got there. But I used to say, Kwame, you graduated summa cum laude, but I was thankful to graduate thank you laude, because that's what happened. I had to make sure that I did not get above 2.0, because otherwise I was going to be an educated fool. And I was fearful for that. I didn't want to disappoint my mother. I wanted to graduate, but I didn't want to be an educated fool. And so I knew that if I did that, that was great. Now, the second year after acquiring that, I got a job at the Library of Congress. And so at the Library of Congress, it did not disappoint me, because I realized that the so-called Willie Lynch letter that we seem to have gotten intrigued over was really way more than the Willie Lynch letter. That there were publications, there were books, and that the slave masters were taught a system of slavery, in which we all became homogenous and homogenized. And so I really got caught into trying to find out what were the traits of somebody from slavery and the whole 9 yards and the whole bit. And then I realized that when the 13th Amendment was ratified, we as a people encountered two problems, one of which I eventually wrote about, because I wrote a book called How to Represent the Black Defendant. And I realized that you couldn't represent black people by what you were taught in law school, because they weren't teaching that in law school about how to represent black people. And so then I realized I had to go back and find out what our problem was. And so I began to reduce that to two areas: reputation evidence and habit evidence. And as a result of that, and if anybody in New York knows me, they will verify this. So I'm not talking about something after the fact. This is what I did before the fact. There were three things I told clients. One, you're not taking a witness stand under any circumstances. That's out. Two, I don't want you to tell me what happened. I don't want to know anything about this case from your mouth. I'm not interested in it. And three, you're not ever pleading guilty. If that thought comes across your mind, tell me now, because whatever we have to do, whatever life sentence you may face or whatever other punishment you might face, pleading guilty is not an option. And so that's how I represent my clients, because you see, there are two problems that really afflict us as a people: our bad reputations and our bad habits. And Dr. Carter G. Woodson addressed our bad habits in the miseducation of the Negro. We have, as a people, not addressed our reputation, even though, interestingly enough, lawyers have not determined yet that we are the only group in America that has a cause of action for group defamation. We're the only group in America out of the 13th Amendment. But, we haven't gotten those creative juices going yet where we understood how we can create or carve out a cause of action for group defamation under the 13th Amendment. And if we did, we would all be owners of the L.A. Clippers right now, in terms of the owner engaged in group defamation. We may be owning the Atlanta Hawks right now, but we haven't gotten to that yet. So,
but Attorney Maddox, this is my thing with that, and I respect your position on that. Again, when we start using the misnomers black and African American and Negro, we know those are misnomers. We know those are fictitious titles. And I want to ask you, because a great deal of my audience wants to know this type of information. You mentioned the fact that you agreed that it's a private corporation within a law school. So my audience will want to know, you said they wasn't teaching how to represent, okay, which is a word we know about here, black people, okay, again, dealing with that fiction. But if they wasn't teaching back then how to represent black people, it sounds to me that they didn't expect black people in their corporation, in their club, because you said that black people had that indigenous status here, and you said that this was a united nation rather than a United States. So if they didn't expect it, they developed their own law school. They came up with their own system with their own founding fathers. They developed their own curriculum. They brought it from Great Britain, I believe you said, or wherever, okay? And they brought that here along with themselves to develop their own nation. I listened to the Dred Scott case. I heard them say, listen, you want to be a part of our club? You come through naturalization. Well, that's not something that an indigenous person can do, okay, or a native. So, this is our nation. You want to be a part of it. You demonstrated to me how they treat people outside of their nation or outside of their belief system. And you told me that they called you all kind of names, and they did you pretty much like they would do in their own house. Same way black people do. I mean, we all have the way we address certain issues. Again, I'm looking at the situation, and I want to ask you the question, does these laws that they've created, statutes, codes, ordinances, 13 colonies, corporate states, are they legally, let's do lawfully, binding on everybody that walks upon this land?
Well, the answer to that is that they are not, but we haven't gone to the point of being human rights advocates. And Malcolm X became a human rights advocate, and he was assassinated. Dr. Martin Luther King came from civil rights and went into human rights, and he was assassinated. So the point of these assassinations is that you will be, your rights will be decided by us and by nobody internationally. That's what that basically means. And so when we see these assassinations take place, these are people who have stepped out of line and have gone beyond where they should go as slaves or descendants of slaves. And so the answer is that for a number of reasons, as well as Dred Scott, no, we're always going to be relegated in this country as, quote, slaves. We're going to always be relegated, and that's been made known to us from the time immemorial. Now, what is significant is is that we hear people say, well, this is a nation of immigrants. Well, it is a nation of immigrants. The problem is we were never immigrants. We were always imports. See, we didn't immigrate into America. We were imported into America.
But was everybody imported, Attorney Maddox? Who was imported?
Well, everybody.
We can be specific.
What I'm trying to say is, as a class, we were imported. You know, I mean, I don't know of any other classes that were imported. The only other class that was here has now been destroyed. And so this is the problem that we are facing as imports. You know, and we have to first get back to defining ourselves properly. And for imports, there is no legal recourse.
Right. Well, you've decided to be a part of that corporation, so he gives you.
No, I have no.
Keep mentioning the word right.
No, you can't put words in my mouth. I have not decided. I have decided to stay with my people.
Gotcha.
I didn't decide to
so
be
you're
a part
not a part of that.
Absolutely not. I'm not in any way a part of that. I've never been a part of that. But I have chosen not to leave my people and to try to do all that I can to educate them, including being pro bono work. So there's nothing inconsistent with what
when I say you, Attorney Maddox, I'm talking about when I say you, I'm speaking broadly of people that if they are giving you your rights, you, and I don't mean you specifically, have decided to be a part of that corporation, and if you are, then they have rules. If you're an employee of that society.
Because those are oath takers. I'm obviously a oath breaker. That's my problem. I have never been an oath taker. I have been an oath breaker.
Do attorneys take oaths to be an attorney?
Yes.
Okay.
And their oath is to uphold Dred Scott and everything else that come in front of them.
Oh, okay. So you had to take that oath, but you just made the decision not to act accordingly.
Well, let's put it like that. I did lip sync.
Okay. I want to transition, if you would, when we talk about the court system, a lot of current events that we can get into. We have the Ferguson case. We have, and I listened to your historical perspective on Ferguson and how it ties into the other case, and that was interesting. But I want to go a step more so in the future of things, in the present and the future of things, where we now have the Gray case, okay, that happens in Baltimore. We have for the first time, a so-called black or melanated, depending on what society, that is the U.S. Attorney General, the highest attorney for the United States. Then we have a so-called black or melanated state attorney, black mayor, black politicians all throughout Baltimore. There was a young man, Freddie Gray, that was killed, so to speak, in custody of police. It appears as though he was abused. I come from a family of law enforcement. I'm part of a big fraternity that is heavily in law enforcement. I have very interesting perspectives and views, and we have, of course, very sometimes heated discussions, and then most times we agree to disagree. With the landscape now with more melanated people in higher positions, this Freddie Gray case, Attorney Maddox, has been interesting because we are seeing, and you spoke to this on one of your videos, we are seeing the power structure turn toward each other. And I guess when you dominate people for so long and you've I guess, subjected them in many ways and indoctrinated their mind to think that they have a power, then you start to look around you and see how much more you can Pac-Man, maybe dominate, maybe, get underneath your thumb. So I find it most interesting that we see the police department, 6 police officers, similar to the amount of police officers in your case with, what was that, Michael? I believe that was the Michael case. There were 6 police officers indicted. We have 6 police officers. Yes, we have 6 police officers indicted in this particular case. 3 so-called white, 3 so-called black, and a black state attorney. And we have one issue with also one thing that you talked about that I really agree with, and that's police unions, PBA, okay,
right,
which are becoming probably to me the biggest visual issue that I don't know if enough people pay attention to. I'm seeing them turn their backs on the mayors, 2,000-3,000 at a time, putting their thumb up, throwing their weight around. We know what culture is running these unions, and you spoke about them, that they're almost turning into the anti-government, running things, political power. I read an article where there was some police union people that were setting up the politicians and bribing them. I mean, all kind of stuff going on, again, in the legal society. Now, we're not talking about the people in the legal society. Tell me about what are they going to do about police unions? We've seen in New York when the other gentleman was choked. We've seen the police say that,
Eric Garner.
We're not going to work. Eric Garner, I'm sorry. We're not going to work this month, and I believe the city lost, some millions of dollars in that month. They said they were pouting and telling their constituents and superiors that we're not going to work. And I'm seeing that a lot. I mean, we're seeing it in the Gray case now. They're trying to act like crime is rising, and the police officers like, well, we just don't feel like working, or we just don't know if we're going to do our job, whether we're going to be arrested. Totally manipulating their superiors, but at the same time, they're all the time on TV talking about once you do as we say, do as you're ordered, don't argue with the police, but in the same light, they totally spit, disrespect their superiors on national TV. Tell me about that, sir.
Well, this is something else that I have told to blacks, and certainly being given the opportunity to speak to you today, I will repeat it. But for those who have followed me, they will already or should already know it. I say to people there are 3 things that you must have in order to competently and zealously represent blacks. 1, you must have the equivalent of a baccalaureate degree in black history. You must have the equivalent of a master's degree in legal history, and you must have at least the equivalent of a doctorate degree in military science. Now, I also advise everybody to have on them at all times a copy of the U.S. Constitution. And the purpose for that is not to believe that you have any rights in the Constitution, but that you should have the rules of the game in your possession at all times. So if you have to have a frame of reference for any argument that you can make or should make, it would be in that small document called the U.S. Constitution and the Declaration of Independence. Now, when you start talking about police union, that's a great subject of mine. And the reason why these are great subjects of mine, because, see, I'm the victims of these things. So, I don't talk to somebody in an ivory tower. I talk to somebody who's been victimized by these things. And so when I first came to New York, as I said, in 74 and 75, but in 76 I started dealing with the criminal law. And in that, I found that the court system in New York was segregated, although the U.S. Supreme Court had outlawed segregation in courtrooms just a few years earlier. Now, when I say segregated, they were segregated in the sense that arbitrary decisions were made about what attorneys enjoy certain privileges. and these privileges were associated with your skin color. So that means that if you walked in with a white lawyer, your case would be called earlier than it would have been had you walked in with a black, or if you did walk in with a black lawyer. So the courtrooms themselves were not segregated in a physical sense, but they were segregated administratively. And so that's when I talk about segregation. Now, when I walked in the courtroom the first day, I was so caught up, in the awe of being in a criminal courtroom for the first time that I will admit that I was not overly attentive. And so I recall that that morning, judges would call cases, and I didn't take any great notice in it. But when we came back at 2:15 after the lunch recess, I looked in the courtroom, and the only thing I saw in there were black defendants and black lawyers. And I said, wait a minute. What happened? And so I asked one of the black lawyers, I said, well, how is it in this afternoon session that it's only black folks here, and this morning there were whites and everybody else here? And so this black lawyer said, well, Maddox, the way they do it is that Mr. Goldstein and Mr. Swartz and whoever else of similar names have busy schedules, and they may be here in Manhattan in the morning, they may go to the Bronx in the afternoon, they may go out to Queens or wherever else, so they have to accommodate them. I said, wait a minute. They asked us that when we first came here this morning, whether we had 2 or 3 courtrooms to go to. They just put our names down. So, how are they coming up with these arbitrary decisions as who should be called first or not, unless it's racial? And so the guy couldn't answer. Now, I knew enough to know not that I was dealing with Negroes who were conditioned to that, and the best thing for me to do is shut up. But I also was fortunate to have had to come back to that same courtroom the next day. And so I said to myself, now, this day, I'm going to get here, and I'm going to make sure my name is first. I don't know where it was today, but tomorrow my name is going to be first on this list because I'm going to get here that early just to make sure that nobody else is here when I show up in this courtroom. And so I did. I wrote my name down first, and then when the case started being called, the court officer said, Mr. Goldstein. I said, wait a minute. What do you mean, Mr. Goldstein? He said, well, I just called Mr. Goldstein. I said, no, if you calling Mr. Goldstein and his client to be called first, then you're absolutely out of order, and that's not getting ready to happen. And so he said, well, you can't run this court. I said, you can't neither if you're going to run an arbitrary fashion. And so from that moment on, my name was put down on a court officer's list as a troublemaker. And so eventually, when I was arbitrarily disciplined, the court officer union was the first union on the list against me. And then you got the PBA, got all the other Sergeant Endowment Association, all the other groups, they were all lined up against me. These were police unions. And so I understand that. Now, the problem here in New York City, and probably the problem in any other major city, and probably any city in the United States, is that the Constitution does not say it in the Second Amendment, but it does say it in the Declaration of Independence that there should be no standing armies in this country over civilian populations. Now, the New York Police Department is a standing army, coupled with the fact that these police unions have bargaining rights and are able to invest in judicial coffers. This is outstanding. This is what the problem is. You can't solve this problem unless you eliminate these standing armies and you eliminate these police unions and you stop allowing them to have collective bargaining rights. That's the only way you can solve this problem, and that's not being done now, and that's where we are.
All right. When you speak about police, and often we do a lot of case reviews, and we understand that for the average person, and I'm going to get into the person thing, most people, we just heard of a politician who was arrested or indicted on certain charges, and one of the charges is obstruction of justice, lying to the police, lying to the FBI. Seems like when you go into court, you're put under oath and everybody else lies. I know you've done a lot of high-profile cases. I know you've cross-examined attorneys witnesses, police officials, public officials, law enforcement, and many times they lie with impunity, and they're never held liable, and they're never held accountable. Before you answer that question, I want you to listen to this. It's going to be about 8 or 9 minutes, and I want you to give me your perspective on it and pick out a case in your time where you probably did something similar to what you're about to hear, and tell us how you felt about it and how does that affect all people. So just hold on and listen to this clip if you would. That's quiet.
When you're at the Border Patrol checkpoint, your duties are to enforce immigration laws and look for terrorists and look for weapons of mass destruction and assist in detecting narcotics. Is that correct?
Yes, sir.
And when you do this, of course, you're following a procedure manual that tells you what to do?
Following policy, sir.
Written policy?
Yes, sir.
You have a copy of the written policy?
No, I do not, sir.
Have you ever seen a copy of that written policy?
That states our authority to conduct immigration checks, or for the checkpoint itself, sir?
For that checkpoint.
No, I have not, sir.
Are you aware of any written guidelines or policies or procedures on how to run that checkpoint?
I am aware that they're out there, sir.
You're aware that they're out there? Let me get this straight. You're testifying right now that you are aware that there are written guidelines and procedures for this checkpoint?
Can you state that question again, sir?
Is it your testimony here and now that there are written guidelines and procedures for this checkpoint?
To my knowledge, yes, sir.
Have you seen them?
No, I have not, sir.
But to your knowledge, they exist.
Yes, sir.
Do you recall on June 1st of this year giving a telephonic statement to Mr. Victor?
I do not recall the exact date, but yes, I do recall a telephonic interview, sir.
Do you recall you were in a room with Mr. Katz?
Yes, sir.
I believe there was another attorney in the room who was a representative of the Border Patrol Union?
Yes, sir.
And you were on the telephone to Mr. Victor?
Yes, sir.
And you're aware that that tape recording was being recorded?
Yes, sir.
And were you trying to tell the truth at that time?
Yes, sir.
Do you remember being asked during that statement if you were aware of any written guidelines, policies, and procedures for this checkpoint?
Do I remember that specific question, sir?
Yes, sir.
No, sir.
Do you remember saying that you were not aware of any written guidelines, policies, or procedures?
No, sir.
Would it help to refresh your memory if you heard a tape playing of your voice?
Yes, sir.
Your Honor, if I may.
If you want to use that one, it's fine.
It starts right at the beginning of that.
Please listen to this tape and tell me if this is your voice and if you remember being asked this question and given this answer.
And, Your Honor, the State's going to object at this point. Was this notice as part of your trial exhibit and disclosure?
Actually, Judge, this doesn't need to be noticed because it's impeachment, which is exactly how we're using it right now.
Your Honor, the same standard would apply to both parties. The State would expect that everything that be given in notice to both parties.
Judge, the law's well settled in Arizona. If the defense had to give impeachment to the State of the State's witnesses before the State's witnesses testified, it wouldn't be much of impeachment, would it? We're simply disclosing the audio tape of the interview that the State's witness, where the State's counsel was present throughout the entire interview.
Your Honor,
I have no understanding what possibly could be the objection to this.
Your Honor, may I have a moment?
You may.
Your Honor, Mr. Victor is quite correct under Rule 613B. The state withdraws its objection.
You may proceed.
Let's ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. I'm there to determine citizenship, sir. If somebody's traveling through there, say, comes to our checkpoint, they're U.S. citizens, they're free to go. If they're not a U.S. citizen, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
And what is your answer that you were not aware of any?
Yes, sir.
Thank you. To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen? And they say no, they're on their way?
No, sir.
Well, which is it? You just said if they say yes or no, they're on their way. But Denias, you've said, I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, that you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go?
No, sir.
Okay, now I'm confused again. I originally asked if you are unable to determine citizenship at the primary checkpoint, that you usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway?
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
And what do you do with them?
I try to establish the citizenship there.
And suppose you can't.
And they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
Mr. Anderson was sent to secondary inspection because of the dog alert. Is that correct?
It was a combination of both immigration and the canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not
Yes.
the dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore,
Correct.
before any immigration question was asked?
Correct.
And Agent Spoonamore gave you that signal because his dog alerted.
Correct.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
Is there any better documentation of U.S. citizenship than a U.S. passport?
No, sir.
So it didn't matter what he said, he was going to secondary.
Yes, sir.
Because the dog said so.
Because the canine alerted to his vehicle, sir.
Is a canine trained to alert to people here illegally?
No, sir.
So the dog wasn't alerting for immigration.
Esquire, that was one of my favorite clips, and I'm sure in your legal tenure you've experienced probably an occasion or two where you cross-examine a law enforcement officer that probably lied as many times in that manner, and you probably said to yourself, or the people within the court said, wow, you are under oath. And give me your position on dogs being used in criminal matters, especially in the manner by which it was used here.
Well, what I want you to do first, before I give you my actual story, I want you to strap down and make sure that you won't fall off of your chair. Because that was a very interesting confrontation between the defense counsel and the law enforcement agent. And I suppose there are three things that you learn from there as a lawyer, is that you must be a walking encyclopedia on the law of evidence and the law of procedure. Because as we saw initially, there was a confrontation or an argument between defense counsel and the attorney for the state.
Yes.
Secondly, what we did notice is that this attorney had to literally pull teeth out of a chicken. And so you really concerned about the role of a judge in those situations. My contention that he really had to do too much in order to try to nail this particular witness down, who refused to participate in the litigation process. But this is what is interesting to me about dogs, is that I actually had an opportunity to witness a dog on the witness stand.
Wow.
And it happened in Albany County. It happened in February of 1990, and the judge was Judge John Turner. And so, there are ways of trying to get the transcript. Even though I tried to get it, they wouldn't give me the transcript, because after I witnessed it, this next thing I want to do was have a transcript of this proceeding. So I have been trying to get that transcript until this moment. and that was 1990. So that's 25 years ago. All right? But this was a case before Judge John Turner, and it was a burglary case. And so the defendant, of course, was black. And I hate to have to say it, of course, but that's usually the best way to describe it. The defendant was black, and he had a white girlfriend in a very hostile environment in which all 12 members of the jury was white. The court stenographer was white. The judge was white. The district attorney was white, and the defense counsel was white. So if you had an artist sketch, you would have everybody white and a dog on the witness stand. And as the conduct of the examination started, the lawyer said, well, Judge, I don't know dog language. And so John Turner said, the judge, don't worry, I do. And so they went through a series of questions, and there were some answers from the dog. And apparently Judge Turner believed the dog, because I can't tell you that I understood the dog because I didn't. But Judge Turner now is not only the judge, but now he's also the interpreter, and is interpreting what the dog says to the jury, and they proceed to convict this black man.
Unbelievable. The dog.
The dog.
I guess that's no different than camera red light tickets. Yeah.
Well, the one thing that I will say, that I had a wide experience in the law, and I've virtually seen most, if not everything, in it. And so when people bring up any kind of experience, I can usually go back in my repertoire and pull out something that will be equal to or greater than what was witnessed in any particular situation. And this is a sad state of affairs of the legal profession, where you have the testimony of a dog confirmed by the judge and totally incapable of cross-examination by anybody to be sufficient to send a black man to prison.
Well, that's common, and I wanted to address that. Esquire, what is the difference, or is there a difference, in your opinion, between a man in the biblical sense, natural law sense, and a person, I guess as defined in the Constitution, 13th, 14th Amendment? Is there a difference between those two?
Well, obviously, this would have been a great question for Dr. King. It would have been a great question for Congressman Adam Clayton Powell. While they may have differed on some points, they were both in agreement pretty much on what constitutes natural law and what constitutes unjust laws, and the obligations to resist the enforcement of unjust laws, because on the reality of it, what is naturally right or wrong seems to always be in much debate, and I tend to stay away from those debates because that doesn't necessarily seem to be a right or wrong answer among debaters. But the issue that interests me is a case that came out of Texas called Texas versus Herrera, and basically the Supreme Court said that a criminal defendant, apparently in this case a Latino, could be morally innocent and legally guilty. so that somewhat underscores the importance of the subjective interpretation of morality, as was the case that you showed a moment ago about the objective basis for an arrest. And that takes us back to the case of Freddie Gray and the interpretation of Marilyn Mosby, the state attorney general in Baltimore County.
Okay. The reason why I asked is that I got one clip. It's about 12 seconds, and I want you to hear how it's described in court. This is the same case, and this is a case, just to let you know, Pastor Anderson is a case out of Arizona where he went through a Border Patrol checkpoint and refused to engage with the questioning, and he was subsequently taken out of the car, beat up pretty bad, and he sued. He had two pretty good attorneys, and he won his case, and I believe he went on to sue for some good money for violation of his constitutional protections. But I ask you that because we always talk about it, and we read law, and we read what a person is defined as in the 13th, 14th Amendment, as well as in the statutes, and it appears to clearly be different. And I played a clip for everyone, and I'll play for you right now. It's just several seconds long, where there's a clear distinction, and this is the prosecutor speaking, between Mr. Anderson and his person. Just listen for a moment.
Your Honor, the key phrase is wasted time. If defense counsel is going to continue to make closing arguments after every witness and every point, raising motions that could have been raised prior to this date, Your Honor, raising issues that counsel... and let's just see... How
can he raise the motion, Your Honor, if he didn't hear the testimony?
Your Honor, the state's afforded an opportunity. The state has been compelled by Your Honor to produce evidence to justify the acquisition of the alleged seizure of Mr. Anderson's person.
There it is, attorney. Justify the seizure of Mr. Anderson's person, not Mr. Anderson. His person. What person would they be speaking of?
There's two distinctions that lawyers use here, and one could be the actual seizure, and this other could be the constructive seizure. And so I can't answer the question, but I just simply say that for every argument, that seems to be two sides.
That's good enough for me. All right. I don't know how much longer you have. That's why you just let me know. But I wanted to get your...
Okay, go ahead and deal with what you want to deal with real quick. I got a few things I just want to say real quick, and then by that time we'll be out of it. Well, I really wanted to go back to two cases that are really on the docket right now as hot items, and one is the case in Baltimore, and the other one is the acquittal from a bench trial in Cleveland. And as it relates to the Baltimore case, I have written some things on that case, and I'm asking people to get ready for us to be in Baltimore on July 2nd, 2015, which is the actual date of independence, which is interesting, and then somewhat to refresh our recollection of the speech that Frederick Douglass made about the 4th of July. But this is my point. Marilyn Mosby did do one thing which has never happened before. She took military action in the arraignment of these 6 cops. That has never happened before. And so, I applaud her for this military action. And when I say military action, I mean the sense that this was a play out of the textbook of military science, where she engaged in a preemptive strike and basically had put this case where we have it now. And obviously there's going to be many wars over this case because the coffers of the law enforcement agencies are unlimited. And so they're going to use everything at their disposal to make sure that we stay oppressed. And I think we need to understand that. So from our perspective, this is, in my opinion, a class action. And the action is being taken against a class of descendants of enslaved Africans. And so, although it is normally customary in a situation like this for the prosecutor to speak for the people, we must recognize that the Constitution said we the people. And in that sense, when a state like, say, Texas decides to prosecute someone, it's always Texas versus John Doe. Now, there are instances like this where, in my opinion, we need to intervene as the entire class. So, even since they're going to come in here with unlimited coffers and everything else, we need to even this thing up, because this is going to be a war. That's what this is about. And therefore, we need to make sure that we are up front and present and on the front lines of the battlefield when this war is conducted. So I'm saying, Warren, that between here and July 2nd, we are examining the laws to make sure that we can intervene as a class. Now, there's nothing wrong with us intervening, because that's something in every case, in every state. There is a right of intervention. There's something in every state. Okay. Also, there's nothing wrong with a class action. That's something in every state, and was authorized by Chief Justice Roger Taney, who not only authorized a class action, but also authorized the initiation of a test case. So in that sense, we're on all fours. We just got to make sure that we execute and make things happen. Now, that's July 2nd. As it relates to the acquittal of Michael Breedlove in Cleveland, Ohio, in which really is a real tragedy of justice in the most extreme sense. And I want everybody to look at this from a historical point of view first, to see how we should behave. And that is, when Dred Scott was decided in 1857, our ancestors immediately hollered the ballot or the bullet. They immediately hollered that. So the point that we don't ever hear about is the fact that when Lincoln refused to take our heed and then come back with the Emancipation Proclamation to recognize that the Union Armed Forces were in trouble, we then joined the Union as a class. This was a class action. You know, the Civil War was made up of different interest groups. That's the reason why people say, well, we don't know what the cause of the Civil War was. We don't know what was slavery. We don't know whether it was trade with foreign countries. You know, we don't know whatever it was. Well, it was all of that, because there were different interest groups that were involved. And so everybody decided that, hey, we got a part of waging war. So black people decided, hey, we need to be in it too, because we're talking about now our emancipation, at least, if not our liberation. So we need to make sure we're heard. So our people immediately dropped whatever they were doing and joined as a class to at least get emancipation, if not liberation. My point is that Dred Scott was a civil case. It was about diversity of citizenship. Here is a case of human life. This is a case about human life. This is a case about crimes against humanity. Anytime you can shoot 137 shots and kill two unarmed defenders, two persons, then we got a real problem here, especially when this judge, in an unethical fashion, decides there's no case of criminal liability on the part of Breedlove. Because what he had said is that the very reason why our ancestors went to war in the first place after Dred Scott, he has now reinstated Dred Scott despite the 14th Amendment. And so as a result of that, his actions are clearly unethical, and there should be a call now for his impeachment. You know, I'm calling for people here in New York to meet at the Freedom Party and be over there all weekend to have study groups and understand what has to be done. But we need to come out firing in terms of making sure that any other judge in this country understands that giving a bench trial to a rogue cop and allowing the rogue cop to get right back in the street with his armor is not acceptable. And we have to do that. This is a matter of self-help. This is not. We can't rely on the U.S. Attorney General. We can't rely on anybody. We got to do this ourselves. This is a matter of self-help. So, you know, the idea that somebody else getting ready to ride in on the white horse and save us is not getting ready to happen. This is a class action, and the class must be present in Baltimore and in Cleveland, and efforts are going to be made for us to deal with Baltimore on July 2nd, and certainly efforts are going to be made to start the impeachment process against John P. O'Donnell in Cleveland, Ohio, immediately.
I respect that. I mean, definitely it was a tragedy, but I'm gonna be honest with you. It's a tragedy that there were 137 shots fired. But from a legal standpoint, I guess, in my minimal knowledge, I don't intend to live my life trying to dissect something that we all agree is prejudicial towards most people, white or black. But his decision was upon belief that he said he couldn't determine whether that officer's 15 shots, I believe he jumped on a car with a shotgun and I believe shot about 15 rounds in the car. We don't know if he was shooting a dead body. We don't know if that bullet killed them. We don't know if it was an abuse of corpse. I mean, it's just what I've seen, counsel, is that within that society, look, if we don't know the statutes, and they change, they move and change overnight, and then this is the word that I went over this Tuesday that becomes the most dangerous word in that society, and that's discretion. That means the law applies, but I can decide when and how I apply it. That's a dangerous word to me in philosophy. In addition to that, I have to agree that how do you know that was he wrong for shooting that many shots and jump? Yeah. Was he rogue? Absolutely. Did he deserve a charge? Yes. But I believe that he was charged with murder because they knew murder wouldn't stick. You can't say it's murder when there's 137 shots. And then he comes afterwards and he puts in another 15. You would have to charge everybody, not him. So this is where I see the customization of something that's nothing, because how would you charge him because he jumped on the hood and fired 15 of the 137? To me, it's kind of ridiculous. You charge them all or you charge none of them?
Well, you see, but the thing about the law is the law itself is not as exacting as the argument you're making, because the law itself has presumptions. So, you know, in the sense that you don't have to actually know. There's a presumption. Just like when you walk in the courtroom, there's a presumption of innocence. There's a presumption that you respond for the consequences of your actions. There are various presumptions. So, you know, I want to say that. But what I do want people to do is to go to my website, which is www.reinstatealtonmaddox.com. www.reinstatealtonmaddox.com, because I have written out the argument for impeachment. Now, what I would like to do, and we're in the process of getting the transcript from the judge, I would like to be able to return to your program with the transcript that I will provide you in advance of any appearance that you may choose to make on my behalf, and then we can discuss the transcript with a knowledge of Ohio law at that particular time.
Sure, absolutely.
So,
absolutely.
You know,
I have a great deal of friends in law enforcement in Ohio, and, you know, I'll be honest with you, I knew probably about a week and a half before, because of my contacts up there, that he was walking. And this is another issue I have. They already knew he was They already knew he was walking. Private society, they already knew what was going on, because I had two friends in law enforcement told me, he's walking on this. And I said, really? Yeah.
But they were absolutely correct. And the reason why they were correct is because, you see, a police officer has a statutory right to a bench trial, but he does not, or she does not, have a constitutional right to a bench trial. You see, the problem that prosecutors make is that they do not argue effectively against these bench trials, because a police officer is only entitled to a jury trial. And so when you say, well, we're going to deny you the right to a jury trial, then that's a constitutional infraction. But when you say, I'm going to guarantee you the right to confront your peers, then that is no constitutional infraction. So this is why these jury trials are being avoided, and why these bench trials are being elevated. Now, the thing about John P. O'Donnell was that he is a favorite of the police unions. And so as a favorite of the police unions, he should have been checked by the administrative judge. Because in any city of the size of Cleveland, or in a city the size of Dallas or Houston or Fort Worth, whatever, there's always going to be an administrative judge, because there are going to be several judges. And those administrative judges should have to be obligated to decide first how this case is assigned. The one thing that you won't do as an administrative judge, if you're ethical, is to assign a case like that to John P. O'Donnell, who's already indebted to these police unions.
Now, you said administrative. Why did you dub him an administrative judge?
No. What I said was, overall judge, there's an administrative judge. So
okay.
if you're in a jurisdiction, let's say like Cleveland, where you have to have 5 or 10 judges at least, there's an administrative judge who controls the whole process. And so what I'm saying is that when that judge decides who's going to be appointed, the judge should take great respect to the fact that John P. O'Donnell has received large sums of money from a police union, and therefore he has a conflict of interest. And that's how that is usually done. And I'm saying that is what did not happen in Cleveland, and that you allowed the fox to control the chicken coop. And this is the result, and this is a natural result. And this is the way the fox naturally operate. And for those who really believe in natural law, I read there wasn't no violation here, But obviously there has been. And when you fire a weapon 137 times, this constitutes a crime against humanity. It's more than just murder 2 or murder 1 or whatever. This is a crime against humanity, and this has to be addressed. And the only way that it can be addressed now is through the impeachment process, which is a part of Ohio law.
Attorney, when we look at the nexus between attorneys, and all of them are bar attorneys, and we look at defense attorneys, we look at the nexus between prosecutors and police unions, and with that tied in with corporate interests. It just seems like that private corporate system is just a system that I just don't see ever being fixed. If you're going to impeach one, you might as well put a bunch of them in there and do them all at the same time.
Well, look, I agree with you about the private system. I've demonstrated to you how I personally know you're correct. I'm not talking about being theoretical here. You're absolutely correct in every respect. All my experience suggests that. But my point is that as long as you're in the game, you got to try to win.
Right. I see what you're saying. I take that. I want to ask you about something that you said when you said, especially with regards to the Baltimore incident. The information that's come out for people like us that try to study law and the far-reaching and abusive at times laws that I extrapolate a lot of things from there back and forth, especially when two powers are battling. What I learned is that, which I didn't know, is that the police department and the attorney's office are separate and distinct agencies. What I also discovered is that, I want you to address this for us because this is a topic that we had recently. What we learned is that when Freddie Gray was arrested, he was taken to, obviously, the county jail, which is under state law, right? And he was arrested allegedly for, this was Baltimore City Police, one of the biggest police departments, I believe, in the country. They have about, I think, 4,000 officers. I don't know. But anyway, allegedly he was charged under, I don't know if it was state or city code for a knife, a little fold-out knife. Now, when the things hit the fan, usually for you and I, or I'm not saying you specifically, mainly anybody else, there wouldn't be an argument as to which law it came under. They would just pick one because nobody else knows. Who knows? You had a knife, we said it's illegal. People are going to take that for face value, pay the fine, or you're looking at less than a year in jail under the city law. And then there was an argument that Ms. Mosby was charging them because the city law, to which they have jurisdiction of, said that the knife was illegal. Now, I read that code, and that code is so vague, it's void, okay, because you can make it go any way you want, and using that magical word of discretion, they would have made it fit anybody they wanted it to fit. But then Ms. Mosley came out and emphatically said to their face, she says, I really don't care what the city law said. I'm a state attorney. I'm charging you under state law, which made me look, and I said, okay, how is there a city law? There are town ordinances as well. There are county laws. And then there are state laws. And I said, how would one know, Attorney Maddox, which, if you cross the street and go to Walmart, there might be another set of laws. If you went to your girlfriend's house across town, if you went to church, there are 4 separate jurisdictions, three separate jurisdictions, city, town, county, inside of a state. And the state law has precedence over all of them. Can you tell me how that makes sense and how anyone would be able to keep up with that?
Well, one of the things I really, you did say about time, and I'm going to honor that. But I'll say this. One of the fascinating aspects of law is what is called local government law. And this is an area of the law that black people really need to understand. And I really can't go into it now because I'm really just caught up with time. But I can only say that, next time that I come on, local government law itself should be at the top of the agenda because it has a lot of real concerns that we as a people need to understand, because a lot of things that we miss is because we just simply don't know. And the fortunate part about a program like this is that it gives our people to understand to focus on some areas that they otherwise would not have focused on. And certainly local government law is important. Now, for Ms. Mosby's purposes now, that her arguments now are academic to the extent that, somebody is saying, well, the arrest may lack probable cause because now she has an indictment. So, that's really an issue that would make that an academic argument. Now, my concern, and I'm going to be through after this, I believe that this case should be called Maryland versus Rice instead of Maryland versus Goodson. In the same way that I believe that Brown versus Board of Education should have been called Briggs versus Elliott. Now, and the point there is that the arraignment of people in terms of the indictment is very important. Like the arraignment of the First and Second and Third and Fourth Amendments are important. These things are not just arbitrarily called the First Amendment or the Second Amendment. There's a rationale why they are numbered in the way that they are numbered. And so we need to understand that as well. And so when you get to the defendants, the fact that Goodson is now the lead defendant, even though he was not there when Freddie Gray was arrested, it, to me, raises a serious question. It doesn't necessarily mean that it's a home run for the rogue cops, but it's something that really needs to be cleared up. Because, you see, when we go back, for example, to a case that I was involved in, Fagonas versus Maddox, Mason, Sharpton, and Brawley. That was the arraignment. Well, they didn't arraign that arbitrarily. You know, they didn't say Maddox first, Mason second, Sharpton third, Brawley fourth, arbitrarily. What they said was, and this is the way that it should always be done, is that Alton Maddox was the architect of this. That's why he's the lead defendant. He's the architect. It had not been for him, maybe this would have never happened. But he was the architect of the struggle with Brawley, and therefore he should be punished, and punished under the laws of sedition and not under the laws of defamation, which basically what that trial was about. And so in this case, Rice was the supervising officer, and he was also the officer who was on the scene who ordered the other two police officers, who also were white, to go after and get Gray, and they did. Now, that makes the supervising officer the lead defendant. So I don't know how you can come up and get these three black defendants, these three black rogue officers, as the lead defendant when they weren't even there. They were being ordered to bring up the rear, as we normally are doing. I mean, that's usually our job, is to bring up the rear. So it's hard, you know, I think that we need, as a member of a class, to be heard in court, and our concerns should be expressed. And one of them is why Goodson and not Rice is the lead defendant.
That's right. Well, Esquire, I honor you. I really appreciate your presence, your attendance, and you being here is a very, very celebrated time for us here at THOR Radio Network to speak with you, meet minds with you. Your mind is definitely too deep to fit into any show, but you do have books available, and I urge everybody to go to www.reinstatealtonmaddox.com, and there you will be able to obtain more information on Alton Maddox's history, his position now, the things that he's doing, where he's going. And we thank the Creator for your pioneerism. We thank you for being here indeed, and definitely I would like to have you back again, as everyone enjoyed what you've contributed and deposited here into this network today.
Well, I appreciate that for you and for me and for everybody else who had a chance to listen. And as I said before, I would like to try to get this transcript as quickly as possible to get back in communication with you, and let's try to see where we go from here.
Yes, sir. We indeed will do that. Tell everybody and your staff at the office, thanks for working with us. And Layla, I'm sorry I didn't get a chance for Layla to come in.
As well. Give her thanks as well.
Yes. But we thank you. We'll see you anytime you want. We'll stay in touch. I'm sure Layla would. She's great at doing that. Again, I want to thank Layla for putting everything together. When I give her a project, she carries it through to the end.
That's what happens when you have competent staff.
That's right. Well, peace and blessings to you, Alton Maddox, Attorney Alton Maddox. Thank you for being here. Thanks for blessing us with your information.
Thank you very much. Talk to you soon.
Thank you. Okay.
Right.